Picking up then just on that issue of electronic signatures, another area that directors are dealing with at the moment is the execution of contracts and documents. There's a range of legal considerations in this area and in general, not just in light of the COVID-19 pandemic. And the following slides will cover the key considerations, such as ensuring that the person executing the document actually has the authority to execute, the remote execution of simple contracts and then of deeds, how documents can be witnessed remotely, and what to do about documents requiring the affixing of the common seal, which is less common these days, but sometimes you still come across that requirement in certain transactions. So if we look first at the authority to execute, this is a very important issue in the current circumstances, because in the absence of an actual change in law, a contract may be held unenforceable if the person executing it does not have the relevant authority. And it's important to understand that authority is not the same as capacity to enter into a contract. Capacity is concerned with whether a person or an entity recognised by law as having the legal personality can enter into the contract. Authority deals with whether the person or entity has permission to enter into the contract on behalf of someone else, and contracting authority is determined by a mixture of common law principles of agency, legislation governing the specific entity, and the entity's own governing documents, which we mentioned, such as the Constitution or the Articles of Association. In terms of the execution of simple contracts, it should be noted that there's different laws in place with regards to execution formalities for these simple contracts as opposed to deeds. In the current circumstances, we're seeing a desire or a tendency to relax the formalities which are imposed by law, and that is understandable. However, as I said, it should just be noted that there is a risk in relaxing these formalities, that arguments may arise at a later date over whether these documents were validly executed at all. In terms of simple agreements or contracts underhand, virtual execution can be done by using email to transmit scanned copies of physical signed signature pages. You can also use electronic or digital signatures to execute documents where the encryption technology provides verification of the signature being attached to the document. One thing I would caution, and again what we have seen lately, you need to take care in executing international contracts, as legal considerations may apply to the execution of parties based overseas. So again, it's recommended that you consult a local legal practitioner to avoid disputes over invalid execution later down the line. There are some further considerations to be aware of when dealing with the execution of deeds. A document that is to be executed as a deed must be in writing and is validly executed as a deed by an individual if it is signed by him in the presence of a witness who attests the signature. A witness must not be a party to the document if they are connected to or a family member of the person signing the contract. It's generally regarded as best practice that that witness needs to be unconnected. Now we understand that that may not be practical in the current environment given the public health advice on social distancing, and we are aware of instances where signatories have had no choice but to get members within the same household to witness those documents. In this regard, we would just advise caution, and where at all possible, in the absence of any change to law or legislation in this area, we would advise that you try to get a witness to those deeds who is an unconnected person, not within the same family as the person executing the deeds. There's a decision known as the Mercury decision, which may help in the current circumstances, in that it provides guidance in terms of the electronic or virtual execution of deeds. And most of your advisors will be aware of the provisions of that case in terms of exchange and delivery of deeds. In summary, it's crucial in the current circumstances, therefore, that you take expert legal advice in terms of the proper execution formalities in order to ensure that there can be no challenges to the validity of documents down the line when reliance upon that contract could be fundamental to your business's ability to recover from the economic impact of the COVID-19 pandemic. And deeds are usually documents to do with transfer of property or more serious contracts where parties wish to have the benefit of a longer statute of limitations, or indeed maybe financing documents or loan agreements. So they tend to be documents that are important, if not critical, to the business in question. And really you want to try to avoid any disputes down the line with a counterparty trying to argue that the deed or the agreement is invalid because it hadn't been properly executed at the time. In terms of documents under seal, there is currently no electronic means for affixing a seal to a document. Companies may grant the power of attorney, which isn't a deed and doesn't need to be executed under the common seal, to one or more individuals to execute documents, which includes deeds on its behalf. The attorney can then execute the document using his or her own electronic signature where appropriate on the company's behalf without any requirement for the company seal to be affixed, but the signature must be witnessed if the document is a deed. This may be a practical solution where a company is presented with a situation where the document needs to be executed under its common seal, but the signatories and the common seal are not necessarily in the same location, as we expect to be the case with many companies at the moment.